No one will tell you this, but passing your bar finals is purely strategy. You don't have to be the most intelligent person in the room. You don't have to be the smartest in your class. You just have to know the secrets to how to answer your questions and what exactly to do, especially during the exam period. So in this video, I'll be sharing with you the secret to acing your bar final examination in Nigerian Law School, how to study better, the question style, and even at the end, we'll also answer a question together so you know how to answer start to finish. If you've ever been confused about your drafts, how to answer questions, this video will give you all the clarity you need. So let's begin. Hi there, welcome to the channel. If you're new here, my name is Lynn. I'm a lawyer, entrepreneur, and digital creator currently based in Nigeria. Please subscribe to join the tribe. I'm assuming that if you're watching this video, you have your exams coming up and you're thinking about studying strategies and how to pass your bar finals. And let me tell you something, you are in the right place. So let's get right into it. I'm always someone who likes structure and I always document stuff. So all the tea in this video is not just for my personal experience, but experience of my seniors, those who have done excellently in their field of study, my colleagues as well, and wisdom from my lecturers as well. So you're in for a ride. Now let's begin. Firstly, I like to pray that God gives you the spirit of wisdom to understand what is being spoken in this video and not just listen to it or watch it, but actually have the bias to take action. Because to be honest, you could watch 50 videos on how to ace your bar finals, how to study better, but if you don't take any action, you will never see results. So first off, let's debunk a little bit of myths in your mindset before we go into the strategy. Because I realized that some things that limit students from actually acing their exams is not because they're not smart enough. It's just because they have this limiting belief in their mind that are probably not qualified enough to get caught the bar, or that they will never pass their exams, and that's why they never pass, not because the exams are hard. All right, so Nigerian bar finals exams is not the hardest exams in the world. Repeat after me, it is not a hard exam. Repeat after me, it is not a hard exam. And I'm saying this from experience, because if you take it to be hard, I promise you it's going to be hard. So that's the first myth we should debunk. It's not the hardest exams in life. If anything, you've probably even written harder exams during your LLB more than what you encounter during your bar finals. Number two, studying can be easy. In fact, studying can be sweet if you don't overwhelm yourself. Okay, so if you're someone who is probably in the hole of not being able to study, you are exhausted, just have this at the back of your mind. Studying can be easy. Studying can be sweet, and I'll teach you how. Number three, your grades while you're studying, your grades in your university are not a reflection of your worth or your intelligence. I always say these things. So many things and so many factors go into your results, and you don't want to be that person who will always be like, oh, I know I'm the problem. My intelligence is the problem. My smartness is the problem. The moment you have that kind of mindset, it's over. You are not going to pass your exam. This one is not even a joke. Now we are done debunking the myths, let's go into the main tea. Nigerian Law School exam format is in two ways. You have your multiple choice questions, which will be done in one day, and then the theory questions, which will be done in different days. Now you have 5 courses, as you already know: criminal litigation, civil litigation, corporate law practice, property law practice, and professional ethics and skills. All right, so we're going to divide the studying strategies and how to answer questions individually for these different exam types. So now let's go to the multiple choice questions. So for the multiple choice questions, you're supposed to be answering 100 questions, 20 each from the 5 courses you have, and you're supposed to answer this within an hour. So that means they're testing not just your intelligence, but your time management. And you don't want to be the person who finishes early but finishes bad, and you don't want to be the person who finishes well but not finish on time. All right, so now let's get right into it. The first thing you have to remember is that every single course or no area should suffer. I see a lot of students studying corporate law practice like it's the only thing that matters in the world. Honey, it's not. You have ethics, which might probably be the reason why you fail. You have property, which you'll be underestimating. You have civil litigation, which I like to call evil litigation, but it's not evil because you have the power to conquer that evil. So now, when you think about this, you have to have time dedicated to study each and every course. There are multiple choice questions, and when you're studying for multiple choice questions, you want to look out for 2 things: some keywords and the area of law. Sometimes you might think you've gotten an answer just because you've read it and you've seen something there, but pay attention to things like except, including, all of those things that you have to read the question, right? So first thing I'll say is do not let any area suffer. Make sure you have time dedicated to read it and answer multiple choice questions. When you start studying for multiple choice questions, focus on your outcomes rather than your results. Learning outcomes are such an incredible way for you to study. So for instance, you want to learn about incorporation of a company. Your outcomes should be something like: who are the promoters? How do you register a company? What are the documents required? Who are the people involved? Okay, what are the steps? All of those things. So you know that when it comes to incorporation, you are well versed in accurate knowledge. So when you want to practice questions, you are not devoid of knowledge. So the second thing I would say is for you to track your progress. Some people don't track their progress. They are so focused on that one topic that they have not learned or they have learned. One thing you don't want to do is not know how far you've come or how far you have to go. I always do this thing in school where if I've read a particular topic, I'll say, okay, I've answered multiple choice questions on this. The next day, I read this topic in this subject and I track my progress. So make sure you track your progress. It's so important because that's also a good strategy to be encouraged. If you're not tracking what you're studying, then you'll probably be overwhelmed. So track it. Be sure you track it. Now that you've studied, you've understood the outcome and you're tracking your progress, you have to track your time. When I say answer your MCQs, I used to finish like in an hour, 10 minutes, 15 minutes, 20 minutes for 100 questions. But as the time went on with consistent practice, I started finishing within 60 minutes, 58 minutes, 44 minutes, 50 minutes. And this happens depending on the year and how voluminous the questions are. Okay. The fifth strategy I will give you is to understand and read topics individually and answer MCQs for those topics individually before you come to practice a cumulative MCQ. All right. So now, if probably you've read on deeds of assignment, power of attorney, there are all these practice questions that are mainly for MCQs. There are about 100 questions or so. I can't remember. Make sure you're able to answer all those questions, okay? Because practice makes you better. Practice makes you know if what you've actually studied or your outcomes are actually in your head. So do you get it? So before your exams, you also need to make sure that you practice past questions a lot. Your lecturers can be creative, but they are not as creative as your God. So make sure that you practice questions and think out of the box, apart from what is in the past questions, and think if you can answer it. Now, when it comes to your exams for multiple choice questions, listen to this. Not every question should be read entirely, especially when it's a long, voluminous essay. The first thing you have to do is read the question. All right, read the question first and then try to trace what part of that particular problem relates to that question you're about to answer. So for this is always common in property law practice. You will see one very long transaction. There is assignment happening, there is lease happening, there is just a lot happening, and they ask, and there's also a will, for instance. And the first question will probably be, what happened to the man's estate since he doesn't have a residual clause? And you've wasted your time trying to read all those transactions. Meanwhile, the question will probably be something you could have answered even without looking at the question. So make sure that you read the questions first before reading those long essays. And once you read the essays, think in your head, right? This question is about will. You don't need that long thing. Just go to where you can find the will and read that part and answer your questions. When you're not getting understanding, then you can start maybe reading from the top. So for instance, you also have a question like, I'm also using property law. What kind of transaction is not covered in this scenario? And you probably have 5 transactions there. Now, what this means is that you have to go back to that scenario and read through. But this time around, you are not reading to get a lot of details. You are reading to find out what transaction is removed from it. So once you find assignment as part of it, you remove it. Once you find lease, you remove it. You just do like examination method so you don't waste your time. You'll be thinking you have 60 minutes, but that'll probably be the most shortest time you ever have in your entire life. But I pray that's not your case. All right. So also on your exam day, one thing you want to do is to be relaxed when you see your MCQs. Make sure you finish it subject by subject. Don't do 10, 10, 10, 10, 10. You know why? You can get easily confused. So if you start with criminal litigation or civil litigation, whatever it is on your paper, and you start answering it, if you don't have your answers within 10 seconds, then you can leave that question and go to the next one. But one thing you will not do is answer 5, 5, 5. That's a very dangerous thing to do. Answer 20, 20, 20. Answer 20, 20, 20, because that way you have a more structured mind. Otherwise, you will distort the flow in your brain. But if you think you can do that, go ahead. The last strategy I will give to you is that once you are done answering and you have enough time, go through your work. Some of those things that probably asterisks in your question paper, you're like, you're not sure about it, you are a bit skeptical. Then if you have enough time, you can go read your scenarios and then answer it better, and make sure you shade your answer sheet very well. Okay, so now let's go to the theory question. So now theory questions, they come in 2 styles. It can either be draft or short answers. And let me tell you something, drafts are an easy way to get A throughout your bar finals. If you're not drafting and your excuse is that you're scared of drafts, I will help you know how to draft better. Because if you cannot draft, then you've just decided to fail at Nigerian Law School. And this is not even a joke. Drafting your exams. So now I'm going to teach you how to learn how to draft better. Then I'll explain the short answers and then we'll do a past question together. And if you're watching this video up until this point and you're finding it valuable, please give it a big thumbs up and subscribe to the channel and share with your friends. Subscribe so you can come back and come watch it again if you did not get anything right. So let's get into it. Drafts. Remember this and never forget it. HBC. If there's anything you take out of this video, it should be HBC. Every single draft has a heading, it has a body, and it has a conclusion. Let me give you an instance. A motion or notice, for instance, has a heading. And what heading would that be? The heading of the court in which the motion is coming before. All right. So, for instance, we have something like in the High Court of Lagos, in the Ikeja Judicial Division. These are basic things that should be at the back of your head. Okay. Now, let's go to heading of, let's say, a meeting. What should it be? Should it be a court? Isn't it a company's meeting? Of course, it's a company's meeting. So, what heading should be there? The company's name. All right. Now, it's going to be a letter. Okay, who are you addressing the letter to? That should be the heading. Or who is the letter coming from? That should be the heading. So now going to the body. Body of draft is where most of the business for a draft goes on, right? So the body of draft would include the details you want in a draft. And every draft has its special body. The body of an arrest warrant is different from a deed. So knowing what you're drafting is obviously going to help with the body. We're going to speak more into this. In conclusion, know this and never forget it. Every single draft is dated except is a letter. Every single conclusion of a draft in Nigerian Law School is dated unless it's a letter. Repeat after me. It is dated unless it's a letter. It's such a good strategy for you because once you don't even remember what to say, just write dated this dash day of dash. All right. And then if it's a company, then you can sign as a secretary or the director, as the case may be. If you're drafting a charge, let's say you are the state prosecutor, you sign there. Okay, you see how this is working? And let's say it's a deed. You finish signing as someone who, you finish the date and then you say, okay, the witnesses, they sign. You see where this is going? It makes it easier. Every single draft ends with a date unless it's a letter, which ends with yours faithfully and then your signature. Okay, and even letters have dates, just that it's not at the end, it's at the top. Sense. So now the second thing you should understand when you're studying for your draft is know the purpose of the draft. Some people just want to draft, you just want to learn draft. People are saying draft in class and you're just like, what is draft? Let's go and draft. Know the purpose of the draft. Once you know the purpose of the draft, it makes it easier. So even when you get exams and you forget every single thing, you're just like, oh, what is this thing? What is this question saying? Let us join this particular party. That is the purpose of the draft. You are going to draft a notice and you've already given your whole verbose introduction. Take notice that this honorable court to be held on this dash day of dash. You are finished writing that and you forget. Oh my God, how do I start this statement for joining of parties? Don't waste your time. Just understand what is joining of parties. You want to join someone to a suit. So even if the English is not correct, you know that, okay, you are praying that this court will add Lynn Eugene to be who in the case. Why do you want to add her? Who is she? Let's say you want to add Lynn Eugene as co-defendant to this particular suit. Shikena. If you don't even remember anything, remember that one. That's why it's mostly important for you to understand the draft before you start drafting. Because if you understand you're supposed to draft a deed of assignment, in your draft, you have no business not writing this deed of assignment. Don't go and be don't listen to those advice of people telling you draft. No, you understand draft before you draft. And this is so important. And it's not easy and it's not spoken anywhere. It's very important. All right, moving on. You can employ acronyms. If you're someone who does well with acronyms like I do, please use acronyms. Don't let anybody gaslight you into thinking, oh, acronyms don't work. If it works for you, use them. So for instance, in property law, I use acronyms. In corporate law, I use acronyms because a lot of things are mostly long. So let's say memorandum of association, for instance, I use something like NAWOT, LSS, date, and witness. All right. So NAWOT is spelled NOAT, LSSS, triple S. Yeah. Then date and witness. That's like the conclusion. So now, once I finish writing the heading of the company that I'm about to draft their memorandum, so the first thing there is N stands for name, O stands for object, A stands for address, T stands for type of company. Oh, I still remember. L stands for what's that? Their, I think their limits or their liability. Yes, their liability. S will stand for the share capital, and the other S will be the subscription clause, and then the subscription box. Then after the subscription box, I think comes the date, right? Then the witness. You see, it makes it easier for me. And this is like how many months after my bar finals, and I still remember it because once I'm able to get the beginning, it flows. So if acronym works for you, please have an acronym. Have it at the back of your head that okay, this is the content, but this is how it works. Because some drafts you just need to cram certain things. You just need to cram the order because that's how you get marks. For corporate law, for instance, you're answering something like memorandum of association. It would be unreasonable to write the object before the name of the company. You will lose marks for having your subscription clause coming before the type of company. So do you get me? It's just common that okay, I've understood the purpose of it. I have to learn how to draft it. Okay, some things that you cannot avoid having the structure in your head because that's the only way you can get your marks. So do well to learn a structure. So that will be it for the draft. Now let's go to short answers. Short answers are really easy, right? We just make it difficult because we don't know what to write. So I'm going to take you through the strategies and then we'll practice the question together. And if you have any other questions that you want me to buttress on, leave them in the comments. The thing you have to do is understand the category of questions. Some questions are asking you to list, some are asking you to explain, some are asking you to, comment on the proprietary or otherwise. Some are asking for the advantages and the disadvantages. And some are also assumptions. So you see something like assuming this person was 16, will your answer be different? That kind of stuff. So we have proprietary or otherwise, we have assumptions, we have listing, we have advantages, we have explanations. All right. So now let's get into the tea of how to study for this type of questions. When you're studying, make sure you have outcomes. You are reading promoters, you have to think, okay, I'm done reading promoters. Can I answer who a promoter is? Can I mention its duties? Can I mention who these people under law can be and who they are not? That is a smart way to study. If you finish studying and you cannot answer what you studied, you've not really studied, you have to go back, right? So you can use the handbook to like kind of get your outlines because they'll tell you what will be discussed on that particular topic. So all those things are going to be discussed. Be sure you know them. All right. That's how you can answer these short answers. So the types of questions, when you see list, you just have to start with a short heading and make sure you list them. When you see explain, you list and you explain. When you see proprietary or otherwise, you mention that it's proper or it's improper and you state why. We're still going to practice this, so don't worry too much. And when you see an assumption question, you also answer the assumption question from the point of view that was given to you, not what is already in the scenario. So now when it comes to if you're in the exam hall, I'll always advise for you to draft first and go for the questions that are really easy to answer because drafting might take time than short answers because if you are able to write something small and it's the correct thing, you get it. But if you draft and you draft halfway, it's most likely not going to, you're most likely not going to get a lot of scores. So let's go. So now let's practice a question. I hope I'm not boring you, but I know if it's important to you, I'm sure you'd have watched up until this point. So let's practice. What year is this? So let's practice a question in property law. So I'm going to like put the questions up here and then we can discuss it. So it says that sequel to the board prospect in real estate business Nigeria, Abiola and Folake of 13 Joe Street, Yenagoa Bayelsa, who were classmates at the Nigerian Law School, have decided to carve a niche for themselves in the real estate business. To this end, they secured a loan of 100 million from Peace Bank PLC, which was used to purchase 10 acres of land and Ubon Drive, Oka, Akwa Ibom State. Abiola and Folake have contemplated whether to sell, lease the property. Answer the following questions. This property law, by the way. Okay, state the differences between the transactions contemplated by Abiola and Folake. You already know that they are talking about sale of land and what lease. Let's first start by an introduction that acknowledges the question. So, property contemplated between Adiola and Folake is the sale of land and then lease. So, first, sale of land is this, okay, and has these qualities. For instance, then if you have a case, you should always have a case. You should always have a section. At least it makes your work, it gives you more mark. They give marks for authorities. You already know this if you're a law student. And then you go to the second one. A lease is this, all right? Because if you're not mentioning what it is and their differences, you've not really answered the questions, because I told you to mention what the difference between them. Some people might also take the opportunity to draw a table. You can do sale of land here, lease at the other side. Once you explain, you now start saying difference number one, difference number two at the other side. That also works. Okay, B question says, assuming the duo, see, assumption question is here. Assuming the duo authorized Mr. Benjamin of 18 blah 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 to manage their property on their behalf, draft both the first and the last clause of the instruction of delegation. So when you read this question, what comes to your head? There is a delegation. What's one instrument that you use for delegation? A power of attorney. They're asking for the first two and the last two clauses. So what are the first two clauses of a draft for power of attorney? Your commencement clause. This is always like, this runs through almost every property draft. Unless it's a letter, it's always the commencement clause, all right? With the commencement and the date. But some people, because they are scared, they probably add appointment clause. Well, I don't know. What's the last two clauses when it comes to a power of attorney? It's to be execution and attestation, all right? So that's out of it. So number C is saying, outline the 5 advantages of investigation of a sale of land transaction. This is already a outline question. So outline would not particularly be so much of an explanation, but a short stuff. So instead of you writing something like, oh, to avoid encumbrances, you might just add something a little bit on it. So you start by saying something like, advantages of having search on a property. Number one, you mention, all those things now. Encumbrances, to avoid the buyers beware maxim applying on you, to know the structural details, all of this stuff. So like, you get it. D says, state the circumstances under which solicitor can act for both parties in the property sale transaction. This is actually a simple question, not to be fair. Property law is actually sweet. So you just write, these are the instances where a solicitor can act for both parties include, that answer. It's when maybe the value of the property is not a lot, it's connected. Let's say it's a business, maybe the parent company and the other company. Instance where there's been agreement by both parties. Those stuff, it works. And then now let's try corporate law practice. A Nigerian PLC was incorporated on January 22nd, 2014, issued a minimum share capital of 2 million. The company's main object is the manufacturing and exploitation of automobile machines. Mr. Wilson, managing director, blah blah blah, a chartered accountant of 10 years field experience, is first only auditor of the company. Answer the following questions. So finally, question has come. Comment on the propriety or otherwise of the appointment of Mr. What do you do? The appointment of Mr. What's his name? The appointment of Mr. Van Smith is proper. The appointment is improper. That's the first thing you say, and then you mention the reasons why it's proper and reason why you think it's improper with your authorities supporting it. All right, and then B says, assuming Mr. Smith refuses to vacate his position as the auditor, leaves the procedure, if any, to be followed for his removal. So now there's an assumption question. So you can say, assuming he has refused to vacate his office, the procedure for removal would be this. Let's say removal by the board or by members, and then you mention the procedure for removal. Now all those things that come after. They'll send a meeting, blah blah blah. So number C is saying that draft a resolution for removal of the auditor. If you listen well when we talked about drafting, you know that now you have to understand what this draft is. It's a draft for resolution of removal, right? They've already removed him. It's not a notice for the meeting. So what should be the heading? The company that has removed him. Okay, the person that addressing it to, the company that's removed him. Now the date, their rep, all of those things, and then the topic, resolution for removal. What kind of resolution is it? Is it ordinary? Is it special? What kind of resolution is it? You write it there, and then you also write the details. A so meeting, blah blah blah, was passed, and then he was removed, dated, signed. All right. D says mention the content of the financial statement. Content of financial statements, you just mention it there. It's not hard. As a company secretary, who are the persons who are qualified to be auditors of the company? You also mention that the persons qualified to be auditors are so, so, and so. So that would be it for how to answer questions. If you want us to have more, in depth on how to answer questions, probably have to do that on a live or something. But it's only if I see very much interested people. So if you have like 20 comments, we'll know that okay, we have like a room full of people to have that. What the key takeaways you take from this video, please have a bias for action. You want to get good grades, no before mouth. Just learn the strategies and remember what I first said. It's not the hardest exams you ever write. Studying is not difficult. It's not hard. It can be sweet. Just apply the principles. The third one I will say is that please make sure your details on your exam slip is accurate. If your number is 154, don't write 145. Please make sure you write that your exact number. You write the date. You write everything, and please write legibly. Write legibly. Have the time. You have good grades, but they cannot see what you've written. Have the time. You've written something that is old, but they cannot see what you have written. There are over 1,000 people. Please, for your own good, write legibly. Write big, if that's what it permits. Collect extra sheets, please. You're entitled to it. Another thing I'll tell you is that please make sure you aim to answer 4 questions. I know you want that your draft to be perfect. I know you want your first question to be perfect. I know you are so interested in your compulsory question, but the instruction is what? Attempt 4 questions. They're not telling you to attempt everything and get them right. What did they say? Attempt. So make sure you attempt 4 questions. Put your hand on your head. That's the only way you can pass. If you answer 3 correctly, there is no possibility. Because if you answer 3 correctly, there is 20 marks lacking somewhere. And if that 20 marks is not added to your what's it called? You cannot get an A. You just cannot. So you have to make sure that you do what? You answer every of them. Attempt all of them. Get something from everywhere. If it's too difficult, jump to the next one. If you're not confident enough in your studying, please engage other people. Don't be there saying, me what you're feeling. Don't do that to yourself. Edro, I beg you. Because of your mother, because of your father, don't embarrass your family name. That'll be it. Thank you all for watching. You guys should be thanking me for helping you. Anyways, thank you all for watching. If you find this video really helpful, leave it in the comment. Send to your friends, please. Don't be the kind of person who learns alone and not send to people. Send to your friends. Let me know if you want us to do like the whole live video on how to answer questions. I would love to help you. And if you're also studying for your Bar 1 exams, this also applies. Don't just think that assumption questions are just for Bar Part 2 students. And if you need more help in other areas, let me know in the comments. Till next time, good luck in your exams.